Welcome to this afternoon's session, Bank Document Subpoenas, Tales from the Field. I think in the program, the rhetorical question is laid out, do banks lie when served with disclosure orders or subpoenas for documents in connection with a fraud and asset tracing and recovery inquiry? Ed Davis, my good friend, says that the mother's milk to fraud investigations are bank records, payment records, customer balances, the debits and the credits that go into a bank account. And that is not an understatement. It's central to every fraud case I've ever worked on in terms of recovery, is to move to the scene of the apparent fraud, gather the payment records, see how much value is perhaps removed in an unworthy fashion, measure the size of the problem in terms of value, see where value went so we can begin a forward tracing process. And at the same time do some reverse tracing from the point of the suspected responsible party or offender's address or where he's located, how he expresses dominion, power, control over value, and do reverse tracing through bank records from that point backwards in motion or movement. So dual directional tracing is critical in most asset recovery cases of any substance, but they all relate to getting bank records. And one of the biggest problems we face in fraud investigations is that bank records, in theory, have a limited lifespan. When you serve, in today's modern system of banking, a disclosure order on a bank or a subpoena, frequently, as fraud recovery lawyers, we're facing a serious temporal problem. If some of the core facts of the case relate to documentation that is older than 5 years, or 6 years, or 7 years, depending on the case, many cases require historical records that go beyond 5 or 6 or 7 years. And we get letters back, usually from the bank, when we're asking for older records like this. In the state of New York, when you serve a subpoena on a New York bank, you get typically a form letter from the Subpoena Compliance Department of the bank. The letter says, "Dear sirs, thank you for your subpoena. We advise that you are seeking records, it appears on the subpoena, reaching back to 1997 or 1998 in connection with this matter. New York State banking regulations from the Superintendent of Banking require us to retain records for no more than 6 years in the state of New York, as I recall. And therefore, this is the requirement that we have, and here are some records that we have that are more recent than 6 years, and period, the end, and that's it." This is a major problem when we get these letters. Now, my colleague, Arnie Lacayo, is with Ed's firm, Asti Griaga Davis, here in Miami. Arnie's focus is on financial fraud and recovery matters. I have the pleasure of working with Arnie in many cases. He's represented governments, large classes of victims, liquidators, trustees in this area. Now, Arnie has very extensive experience with Chapter 15, which is the U.S. version of UNCITRAL's model law on trans-border insolvency cooperation. So we take, perhaps if we act for an insolvency office holder from Brazil, they're called judicial administrators. We come to Miami frequently because there are records here usually, and we ask Arnie, please petition the U.S. Bankruptcy Court to recognize the powers of investigation and asset recovery of the trustee or the JA from Sao Paulo. Or we're using a tool called 28 U.S.C. Section 1782 in the United States, open square brackets, discovery in aid of foreign litigation, a crucial tool in our work. But why? Because it's a broad tool. Unlike disclosure orders under English law, where phishing is allowed, not in the English system, but under 28 U.S.C. 1782. Any documents or evidence reasonably calculated to lead to admissible evidence, which is a big, broad berth, are available under this provision. And all we need to show in a petition is we have a foreign proceeding, that exists or is imminently contemplated to be instituted. It could be, well, in some districts in America, it could be arbitration proceedings, some not, but certainly court proceedings, fair game, come to America, and they've opened the shores to discovery, all full, broad U.S. federal discoveries available here, depositions, documentation, everything. The other crucial thing about America in fraud recovery is U.S. dollars. U.S. dollars are settled through FedWire or chip in New York every night. These are 5 money center banks, and they offset debits and credits, baskets of debits and credits all over the world. So when a businessman in Karachi is paying for goods purchased from a businessman in Islamabad, if they're trading in U.S. dollars or another country, let's say in Switzerland, in U.S. dollars, there are 2 accounts, one client account in Karachi, one in Zurich. And if they're in U.S. dollars, and many, many trades, most trades in the world across borders are in U.S. dollars, if they're paying electronically, the payment will be settled in New York between money center banks acting as correspondents for the banks in Switzerland or in Pakistan. That means there are records in New York showing the wire transfer activity between those 2 business people. That means in New York City we have huge access to data in the money center banks when we serve 1782 subpoenas as with a list of names of suspected offshore companies, onshore companies, targets in an inquiry for records dealing with money transfers. So America is a very important place for gathering payment records to help further an inquiry. Arnie, over to you.
Thank you, Martin. It's a pleasure to be here with Martin. Some of the funnest cases I've worked on with Martin. For those of you who were here for the prior panel, you know that Martin does very interesting work, and so it's a real pleasure to be here. As Martin said, we are going to discuss briefly this afternoon the challenge that we face as lawyers looking for bank records in matters that have long histories. And as Martin also introduced, the topic is related to our subpoena power here in the U.S. or the disclosure order in the common law system. I will begin today briefly for the non-lawyers in the room by giving a very brief overview of how subpoenas work here. And essentially, when you're talking about a subpoena, you're talking about a request being made with the power of the court under our rules here. The lawyer issues the subpoena and signs it, but it's with the authority and power of the court behind it. And so the subpoena is the typical tool that we are utilizing in asset recovery matters, either in bankruptcy or with our 1782 matter. But I will add here, and we'll come back to it a little later, that the discussion that we're having here is also relevant to lawsuits. Once you have lawsuits that are ongoing and you have typical document requests within the litigation, party to party, in those instances you're not dealing with subpoenas, but a lot of the discussion that we will have here today about preservation of records, digging back in time, and the case law that you'll hear a little bit about also can have its root in inter-parties litigation where you have discovery that goes on here in the U.S. Basically, the subpoena commands the recipient to do one of 3 things: to show up for a deposition or for an examination in the bankruptcy world. And you know, one thing to add here to what Martin said is that under our 1782 statute that allows for the gathering of evidence for use in a foreign proceeding, we do have that standard reasonably calculated to lead to the discovery of admissible evidence. In bankruptcy, we can go further because our bankruptcy case law here talks about the fishing expedition and the Rule 2004 examination being a court-sanctioned version of that. So we have very broad discovery power here. And the banks are often on the receiving end of those subpoenas. So typically we're asking the bank to show up and testify, usually through some form of records custodian, corporate representative deposition. What we'd like to have happen typically is to have the records produced to us beforehand. We'd like to have sufficient time to go through them and then bring the bank officer in to ask about the completeness of what has been produced to us, any deficiencies that we may have noted, other accounts that we may want to pursue with a separate subpoena or a supplemental request. And sometimes we do without that. Sometimes we will take an affidavit that does that for us, depending on what the client needs. But you do have the power to call someone in for a deposition or examination with a subpoena. The other thing that you do here under the second and third line bullets there is that you can ask for the production of documents, electronically stored information, or tangible things. In theory, you could ask a bank to produce a tangible thing for inspection. And the standard for the bank and for any recipient of a discovery request in the U.S. is that the document or thing be in their possession, custody, or control. So you will hear a little more discussion about that today when it comes to old records, because you have banks that will tell you in the letter that Martin described that these records are not in their possession, custody, or control because of their document retention policies that have caused these things not to be available.
Arnie, when I serve out a subpoena on a U.S. bank out of a U.S. court, is there a document destruction hold that's automatically in place upon the moment of the service of subpoena? Do they have to freeze the destruction of any records pertaining to the accounts?
Typically, the litigation hold requirement is connected with ongoing litigation or anticipated litigation. In many instances, we serve subpoenas that are investigative in nature. So what we're saying to the bank is, you're not our target, you're not our putative defendant, we're not thinking of suing you, all we want is bank records. So what we do in those instances, in the 1782 context and in the bankruptcy context, every single time, is request that the bank preserve records. And so we will make that affirmative request. If we're doing it with the backing of an order, we will ask that the order state that. And it works fairly well, but the advice to you, Martin, and to anyone else who asks is that you make that request explicit. And then to close here is that there's a bullet here that says that the court will have the power to require compliance, and that's typically through some form of motion to compel compliance with a subpoena, and the power to hold a subpoenaed person in contempt for noncompliance. All of those things are provided for in our rules. Now, briefly, I'll run through these quickly. The duties that the bank faces, or the other recipient of a subpoena, are also spelled out in the rules. And the person responding has to produce documents as they are kept in the ordinary course of business, or has to organize and label them to correspond to the categories in the subpoena request. With banks, what that means typically is that you're getting documents arranged by account, with account opening documents at the beginning, statements, documents that flow from statements, like wire transfer requests, wire transfer confirmation sheets, and account closing statements. In a perfect world, that's what you're going to get. That's the way it looks. But oftentimes, as Martin will discuss, and I'll tell you a little bit more about later, that's not what you get. And so we look to that first rule there to make sure that the subpoenaed party is complying. If you don't specify how you want the electronically stored information, which is what most of this is these days, the bank or person responding can produce it in the form of their choosing, or the form that it's ordinarily maintained in. If they give it to you in some other form, it's got to be usable. The standard is that it's got to be usable. The person, this last one here, is relevant to our discussion today, because the person need not produce discovery of electronically stored information from sources that they identify as not being reasonably accessible. And this is where a lot of the litigation will occur with banks, because they will tell you that the records that they're keeping are kept in some form that is old and not easy to get at, or very expensive to get at, and they will not want to bear that burden and cost, and they will try to have the court shift that back to the party issuing the subpoena, or to have the court shut down that aspect of the discovery entirely. So the court, under our federal rules here, on a motion or on its own, is going to limit the frequency and extent of discovery if it determines, one of a couple of things is happening, and that is that the discovery is unreasonably cumulative, duplicative, or can be obtained from some other source. So this is something that we think about. With banks, this doesn't come up as much. They are the source of the information that we need, but it's something to be aware of when you're issuing a subpoena in the U.S. The second thing, and the more relevant one to our discussion today, is that the burden or the expense of the proposed discovery, the court is going to look to see if that outweighs the likely benefit, considering the needs of the case, the amount in controversy, the parties' resources, and the importance of the issues at stake, and of the discovery in resolving those issues. So for fraud and asset recovery matters, it's often possible to say, as Martin said, that these are the key records in the case, that these are the things that will make or break the claimant's claim, and that it should be had. We'll come back to sanctions, but I'll close here and turn it over to Martin after this screen. Sanctions, with a question mark here, are exceptional in our system. And so what the rules say is that absent exceptional circumstances, the court may not impose, under the federal rules, on a party sanctions for failing to provide electronically stored information lost as a result of the routine, good faith operation of an electronic information system. Good faith or bad faith is what will determine the availability of sanctions when it comes to record retention issues. And where issued, those sanctions may include things as drastic as the dismissal of the claims, and we'll come back to that shortly. For now, I'm going to turn it over to Martin, who's going to cover some issues dealing with banks, record keeping, and a very interesting experience that he had with a well-known bank.
Maybe two examples. Banks and record keeping. It sounds like the most boring subject you can conceive of is to talk about bank records. But any of us who actually have to do these investigations know that absent access to them, we have no objective way of showing courts exactly what happened to value. And because our mission in life as asset recovery professionals is really to gather objective evidence of attribution of value of money or money's worth to wrongdoing and wrongdoers. So it's the attribution and the links that are objective, ascertainable, measurable, that win cases, not guessing, not speculation. So we need the records to satisfy the court, the high burdens we're under in fraud cases, to attribute value to wrongdoing or wrongdoers, and that's what the bank records provide. So we have this notion of record retention periods that I outlined in my introduction. When conducting a modern fraud investigation, we know we have to assemble a team, a multidisciplinary team of professionals, investigators, forensic accountants, preemptive remedy lawyers, insolvency practitioners, to have the right human capital to meet the demands of the task of the case. We have to list initially in an assessment of risk the jurisdictions that are likely to be involved in any investigation. For instance, in Brazil, our office is working now on 14 matters. They're all bankruptcy, apparent bankruptcy fraud matters, where 3 banks and the rest are trading companies, 11 trading companies failed by reason of family proprietor-owned, institutional-sized enterprises being looted by proprietors, by senior management or ownership of the banks or the trading companies involved. Total losses in those 14 cases, about $16 billion US. We've worked the first 4 of the 14 cases for 4 years. And so far, we have found and frozen about $1.5 billion of value. And through the identification of what banks to go to and to get the records in order to attribute the value thus frozen, $1.5 billion worth, to the wrongdoing or the wrongdoers. And in those cases, we see a pattern. In Brazil, the value seems to go north-south, right? So from Sao Paulo, typically, wire transfer. So if someone's looting a bank, an example was a case that we fortunately just won an appeal on yesterday called Banco Santos. Mr. Edemar Cid Ferreira, who's been convicted of defrauding his own bank, this period of incarceration, 21 years, yet to be serving his sentence. Criminal appeals in Brazil take a long time to resolve. He took about $1.2 billion of value and transferred it outside of Brazil, principally to the BVI, to a structure there called Alsace-Lorraine, to Bank of Europe, an offshore bank in Antigua, to Switzerland, a little bit of the money, and he reposed a lot of it in about 2,000 fine pieces of grandmasters' works of art. Monet's, Manet's, Degas, Rembrandt's, Jackson Pollock's, many fine pieces of art. Our team has assisted the U.S. government in terms of the freezing and recovery process for the estate. But there were also this real estate in Brazil that was acquired by offshore structures in the BVI and other jurisdictions, Belize, back into Brazil. So the value in that case seemed to flow to New York and Miami banks, used to purchase art to store value, store the art in New York, London, Paris, some in Netherlands, some in Switzerland, some back in Brazil. All held by offshore structures. That was the art part of the job. Cash in banks in Switzerland, a lot of real estate. 85% of the proceeds of the fraud invested in real estate back in Brazil, held by offshore structures. So the mission was to gather banking records to show that the suspected assets capable of being linked to Mr. Ferreira actually were linked to the fraud. And this took 4 years of work of gathering bank records. And we did it usually under seal and gag. So we asked a U.S. bankruptcy court judge to respect our client's powers, as I mentioned, under Chapter 15 platform, and then engage in a court-sanctioned secret inquiry. Why? So that if we find value, pools of value that we haven't got frozen, we don't want to have the investigation frustrated if the other side was to learn how much we knew about the value and where it went. So in this process of secret inquiries, we have in the English system perhaps an injunction enjoining the third-party financial institution from tipping off the customer. Also, they have a public law duty not to tip off under money laundering standards. So they have a criminal issue and perhaps a civil contempt issue if they tip off. In the United States, big subpoena compliance departments are usually staffed with people who are perhaps underpaid, $10, $15 an hour. I understand some of them get paid. Not the sharpest knives in the drawer in terms of reading subpoenas or orders. Oftentimes, they'll receive the subpoena, and it says in bold print, this subpoena is coupled with an injunction from the U.S. Bankruptcy Court. Do not identify or contact the customer of this bank account that is the subject of the subpoena, because if you do, you'll be committing a contempt of court, subject to sequestration of assets of the bank or sanction of imprisonment of the directors of the bank. Do not tip off the customer. And many occasions, the subpoena compliance clerk doesn't read the bold print, and the first thing it does is contact the customer about the subpoena. So having had that happen a few times, we now know better not to send the subpoena or the disclosure order to the subpoena compliance department. Rather, we go to the general counsel's office and we say, look, this is a special investigation. Don't send anything to your subpoena compliance department until you go down there and explain to them what this is. It's a special subpoena. So seemingly that has worked for a few years, this procedure. Although sometimes still it gets broken somehow in the system. So once we serve the subpoena, we get back responses like this, like I outlined before. Dear sirs, thank you for the subpoena. You're asking for old records, 5 or 6 or 7 years old. We don't have them because of record retention periods. So we need to understand in each jurisdiction that we go around the world seeking disclosure relief, what are the record retention rules? In the Eastern Caribbean Central Bank says it's 5 years. I recall Switzerland was 10 years.
Florida, it's 5 as well.
5, 6 in New York. So it jumps around in this time frame. We want to identify the type of institution, because sometimes you'll find that there are no record retention rules, particularly with some broker-dealers, some intermediaries, fiduciaries. They may not have the same kind of rules. Basically, the banking lobby is able to twist the arm of state legislators, places like the United States, and shorten the rules to make their record retention burden less and less and less. Now, if we move on, management of financial records. Now, what we learn is, though, that what you think you get when you get a letter saying we don't have the records anymore because of our record retention burden is only 5 years or 6 years, you learn that that may not be the truth. And oftentimes the letters you get are a bit cheeky because they don't actually respond to the subpoena. The subpoena says, or the order says, disclose all records and provide an affidavit of compliance or some written representation of what procedures you went through to look for records and how and what did you find and what were the issues involved in your internal inquiry. Oftentimes you get the form letters that don't say very much, quote the local record retention statute or regulation, and impliedly say, they don't expressly say, we have no other records oftentimes. They just say, well, thank you for subpoena. You're seeking records that are fairly old. We only need to retain records for 5 years. But they don't actually say, we have conducted a search, we've gone through all of our servers, and we can conclusively tell you we don't have the records you're seeking. They just say, we only need to keep them for 5 years. So we write back and say, well, wait, that's not the question. Thank you for letting us know what the local law is. We just need to know what have you done and have you searched all of your servers to find older records. And then they'll write back and say, well, that's burdensome and we're not quite, we're a subpoena compliance department. We have limited access to other servers. And then this is an example. In 2009, I retained an expert. I learned quickly that because I know less than nothing about computers, systems inside banks, I retained an expert a few years ago to help me through these issues. And his name was Mr. Kelman, a former English barrister who now focuses on being an expert witness on bank systems, computer systems. And he helped me to write a letter to the UBS in Weehawken, New Jersey, which is the subpoena compliance department somewhere in New Jersey for Union Bank of Switzerland in the United States. Now, in 1997, you might recall, Swiss Bank Corporation merged with UBS, and that was important in this case because the old records we were after were Swiss Bank Corporation Stamford, Connecticut records. And we discerned that obviously when the two banks merged in 1997, they had to merge their records. So the expert helped us to do some research. And so we wrote this note. We say, thank you for your communication indicating what the record retention rules are in New York State, or Connecticut, I should say. We respectfully request that you direct your immediate attention to the UBS archivist globally and the people responsible for UBS's disaster recovery plans for electronic data, see below. Whereupon we believe you will find that the task is not as onerous as you're suggesting, and that the records we're searching for, reaching back to 1992, still exist in your disaster recovery servers. So this is a crucial point. Banks have, yes, they have regular servers maintaining customer records. Yes, they have policies to destroy them after so many years, 5 years, 6 years, but they have to retain disaster backup servers. And more often than not, the bank officials who are in charge of destruction of records don't deal with the disaster servers or the offsite servers used to back up the system. And also servers, when you press delete, they don't actually delete the data. You can still find deleted data as well. So we use experts to point that out to judges in cases where there is a particular need in the interest of justice to image deleted data that does exist, that's been deleted because of record retention policies, but we need to interrogate the servers to get the old data. So we go on, and we pointed out that all the records are likely to be held in the archival records of UBS. We talk about the merger between the two in 1997. The IT department at UBS employed 2,000 people. Its computer system was known as Abacus and comprised 15,000 individual programs. It employed Unis mainframes, 100 satellite servers. By contrast, before merger, Swiss Bank Corporation's real-time banking system, which boasted 25,000 separate programs, used IBM mainframes linked to 70 satellite servers, 30 to 40,000 PCs and workstations were linked. So we analyzed by doing research independent of the bank about what the bank had says in their securities filings with the SEC of exactly what happened upon the merger to the two systems in the bank and the record keeping. And we were able to establish from our own reading that, that when upon merger of the banks, they decided to rationalize the system based on SBC's platform, not UBS's, and that there was a centralized way to preserve all data that existed up to that point of the merger, and that it still existed. So we wrote this long letter. We point out what the record retention rules. The Swiss banks are much longer than in New York State, 10 years instead of 6, that they had to comply with Swiss law as well as New York law. So thank you for letting us know what New York law is, but perhaps you might want to comply with your home law as well. And we got back a different response. It was crucial to this case, a Brazilian case, that we get these records that reach back to 1992, 1997, 1998, dealing with about $500 million of payments. And after 2 months of work, providing funding for the discovery of the data in the disaster servers, out came all of the evidence needed to link the relationship between stolen money and assets in Brazil, which led to the freezing of those assets, and it appears the highly probable recovery of the assets to creditors and victims of the fraud. So this is a good example of working with an expert on bank systems to poke and prod. Another example, Rodrigo da Silva in Arnie's firm was asked by me in a similar case in Florida. I said, Rodrigo, please, in response to this letter telling us again what the record retention rule is in Florida, which we know about, please ask tell the bank that we're going to issue a special application to the judge, asking the judge for permission to depose the chief information officer of the bank. Now, if we get to depose the chief information officer, this is, you get a stir of activity from the subpoena compliance department. They say, why do you want to talk to that person? They're way up the top of the bank. Well, because they understand the design and the architecture of the bank systems. They know where disaster data is stored outside the bank. And we need to know so we can go back to the judge and say, Judge, we need further interrogation for the records. There is a special purpose for this investigation. Here's the purpose. All litigation is about risk management and justice. And it seems to us, if our clients are prepared to pay for the time of the interrogation and the investigation of old servers, that we should be able to depose this official so that she or he can help us in understanding how to pinpoint the interrogation of their own data.
In that instance, that request had followed numerous subpoenas, actually, for documents, and ultimately it worked, just like Martin said for his case. Right after that happened, the bank produced records. I wanted to pick up, before you move on, Martin, to your next slide, on 2 quick points, things that Martin raised during his presentation, things that we hear a lot about in this day and age. One, many banks failed across this country over the last 6 or 8 years. And what you hear oftentimes is that a bank that used to exist and was taken over by some other bank can't get a hold of records of that prior bank, or it's too much work to get a hand on the records of a bank that no longer operates. Those records are there. In fact, I think that, in my experience, those records are more likely to be there because the banks take this information and probably don't process it as quickly as they would like to, and it's there. And so that's one point. The second point is that we're moving away from the period of tapes and other means of storage. But in many of our cases, we are reaching back into that era, and those things are there as well. And so it's just some things to think about. We'll come back to some suggestions, but I thought I'd raise those issues.
Thank you, Arne. Another case example of a very poignant example of what I call salting bank records. You know, rhetorically we say, do banks lie when served on a subpoena or a disclosure order? I don't know. I do think, though, that they get disorganized, that they are undercapitalized in this whole area of record retention and compliance with orders. I think generally it's more sloth and incompetence than that we face with this constant requiem about record retention and the ignoring of their disaster servers. That's usually what we face. But sometimes we actually face something that appears to us to be more than incompetency and may actually be more serious. In one such case, our firm acted on instructions by some U.S. lawyers on behalf of a wealthy American family that had been relieved of $32 million of cash that they put into what I call an offshore insurance annuity lockbox, meaning you put the money in, it stays there, it's invested for the family into an insurance annuity in favor of a family trust, and eventually the money, the earnings from the capital get paid out over time. But the documentation for tax reasons in the United States, the documentation has to be very tight so that the family has no control over the value during the currency of the life of the annuity. This was a 25-year annuity product. And so its integrity was really dependent on the integrity of the offshore insurance annuity issuer. As it happens, they had no integrity. And the law firm in Chicago that acted for our clients in introducing this complex financial product and in drafting very extensive documentation to create the annuity in a, quote, U.S. tax code compliant way is an aggressive notion where you don't have to pay taxes on earnings for 25 years. I mean, the IRS is all over these kinds of products, and they require a lot of legal work in order for them to be arguably lawfully avoiding taxes as opposed to be evading taxes. So the family spent $1 million in legal fees with the Chicago law firm to construct this safe house, this secured annuity contract with this offshore issuer. The family then discovered that fees were being charged, bucket loads of fees in the millions of dollars against their capital. They weren't getting proper reports of what was happening to the money. They came to learn that other wealthy families were feeling uneasy about the same issuers of annuity contracts. They hired some investigators and discovered that the lifestyles of the promoters of the product offshore were going very resplendently with Rolls Royces and nice cars and things and big homes in the Bahamas when they started very modestly and now are very rich. So 2 + 2 = 4, and it seemed that money was being stolen, including $40 million of oil and gas royalties in Texas and other assets. So our brief was to figure out a way to find assets, freeze assets, recover assets, our normal brief. We concluded that under English law, or in this case, Anguillan law, the problem with a lockbox is if it's built really well, it's very hard to break it open. Because we have documents that cost $1 million to produce. The family had signed all the documents, signing control of the money away for 25 years. And even if there was some perhaps incompetent or fraudulent investing going on with the money, we couldn't say that we had been lied to before we gave the $25 million. So there's no apparent fraud in the making of the agreements. There was no misrepresentation we could identify. We had big legal problems in trying to go to a judge to get remedy. We needed something more. The investigation, though, revealed that it seemed that the Chicago law firm had received a $2 million kickback, a secret commission through an offshore structure in Nevis and Anguilla. Now, an English judge would understand that you're not allowed to have kickbacks to lawyers who charged $1 million to put the money in a lockbox. Now we could perhaps blow up the structure, freeze assets, recover assets, in simple terms. So, but we needed the records, because it would be professional misconduct of the most egregious kind to accuse a lawyers in Chicago of backhanders and bribes without evidence. You can't just think it. An informant can't tell you. You have to have documents. So how do we get those things? Well, we discern that it was a bank in the Eastern Caribbean Supreme Court region, not the BVI, where in Anguilla, where we had to get a disclosure order. We asked for it under seal and gag. Her ladyship gave us the sealing and gagging relief, but ultimately refused on an inter-party basis, with the bank challenging, which is unusual in disclosure orders. Whenever you see a third party, disinterested in quotes, challenging a disclosure order, there's usually something going on that we can't see. And we lost at first instance. We couldn't get the disclosure order. Her ladyship thought it was unnecessary. I think she misunderstood some of the key points. Unfortunately, we perhaps did a poor job of explaining it. But we took it on appeal, and our Court of Appeal allowed the appeal, and on their own jurisdiction, ordered the bank to disclose the specific records we were seeking. And they are related to maybe 45 bank accounts going over a number of years. We didn't we didn't emphasize the fact that there was a particular company from Nevis that we had good information was the paymaster of the commissions, the secret commissions, allegedly to the law firm in Chicago. So we didn't make it abundantly clear that that was the one piece to the puzzle that we were after, for fear that those records may go missing. So the records came in after 4 months of struggling to find the records. So as I say, about 30 bank account records over a number of years, perhaps 15 companies or persons involved in the investigation, and the bank dutifully had obtained all the records pertaining to all 30 persons or accounts, or 15 persons, 30 accounts, but missing August 1st, 2005 to the end of 2007 for this one commission payor company were the records. These were the records we needed. So we were very upset, deeply concerned that someone was salting, meaning hiding, concealing the very records that were central to the whole case. As it happens, we did an investigation. We found that the off-site storage facility, usually banks hire a third party to store the data for disaster purposes, and we were mounting an application to go directly to them, to go around the bank where we think we had some problems. One of the defendants, ancillary defendants, was a director of the bank, and the orders purposely had instructed the bank's legal department not to let that director know about this whole affair. We think there may have been a leak there. So it doesn't matter. We were going to go to the third party, hopefully with a disclosure order, to open up the disaster servers and hopefully get the records there. But the case settled before we were able to do that. But it is a salutary lesson, this particular example, of how did the bank lie? I don't know. Am I upset about what was going on? Yes. Does it seem like incompetence resulted in the returned disclosure order? No. But these things do happen, and we must be cognizant of other ways to get the same records, and they are out there. In fact, the disaster servers in the question were in the United States, and there would be no way, I think, in this country for people to be starting to salt records dealing with an offshore case. I would think it highly improbable. The third party was a big institutional cloud or server company, and the likelihood is if we had to press the investigation forward, I think we would have obtained the records ultimately. Marty.
Great. I don't know if you have a few more here, Martin, if you want to go through those. I have mine toward the end.
Well, of course, we have standards of disclosure. We have common excuses I wanted to get to. We don't want to comply or can't comply because it's unduly burdensome. The records are not easily accessible. If we executed this subpoena, it would breach foreign law or privilege. We've destroyed the records pursuant to retention policies. The cost of restoration of backup data is prohibitive. Usually money is the answer to many of these excuses, so we have to come with funding in order to make sure that the bank is not out of pocket. In English system, it is clear that we must pay for the cost of compliance. It is clear. Oftentimes, though, offshore banks or third parties are beginning to take some advantage of the claimant party by overcharging, in my opinion, for time. Like in one case, I remember in Jersey, in the same case, we got the same group of records from two trust companies, and one bill for compliance was $45,000, and the other was $2,000, and the $2,000 returned more documents than with more companies than the one with over $40,000. And I asked, well, can we please understand how is this possible? And the people inside the trust company that gave a bigger bill decided to charge very enlarged hourly rates for looking for records, and the time charges were massive. And then their lawyers also wanted to charge very substantial fee notes as well, whereas this other lot were charging a smaller amount. So we were able to go to the judge and say, well, these are the documents we got from this lot. These are the documents we got from this lot. This bill is small and this bill is too large, and the big one got taxed down. But I'm just saying that there is the possibility, because there's no client sort of watching what is happening with the fee notes when they're in this compliance environment, and it really, and I know courts are loath to get into these issues because it's time consuming, but occasionally I think it's helpful if there is a full robust taxation done with some guidance or guidelines about compliance costs, because it can, if you can imagine in some of these cases, if we have to go to 25 locations with disclosure orders and everyone is sort of giving enlarged fee notes, if you multiply that by $40,000, it can become prohibitive to complete the investigation. In the United States, it's not as rigorous. I think compliance costs are, costs of photocopying. They don't get to charge profit on their time.
They get to charge time for searching.
But they don't charge legal fees.
No, not generally, no.
It's just the cost of actually looking for the records and photocopying the records. So I usually find it's about 10% of the cost for compliance in America versus in the offshore environment. Non-compliance. What do we do with areas of non-compliance? Is it due to an inability or to willfulness, bad faith, or any fault on our side or the bank? Oftentimes we can be blamed for coming with confusing, overreaching, vague or ambiguous or overly broad requests. We ourselves should be criticized when we're doing that. We have to be cognizant there was a world of scarce resources. We want to ask only for what we actually need to preserve costs. We don't want to be oppressive to the bank. We want to work with them in a collaborative and sensible fashion. And that means really understand what you need and not just ask for everything.
Generally, the request that will make the bank respond more forcefully is the request where you're asking for information about an account beneficially owned by someone. They don't mind the request that says account number 12345. But when you ask for all of the accounts owned by a certain person, that tends to get more of a reaction from the bank. But you can, and we do. So.
Just a short note, and then we have 5 minutes left, on the well-known case of U.S. versus Bank of Nova Scotia. I think it was 1985 here in Miami, U.S. District Court case. This is the case where Bank of Nova Scotia, as organized, as most Canadian banks are organized, not through to subsidiaries in foreign countries, but through actual branches. So Scotia Bank, as it's now called, had a branch of the big balance sheet in Toronto, sitting in Cayman Islands and sitting in Miami. So the U.S. Grand Jury, the U.S. Attorney's Office, wanted to have the directors or persons in charge of the Miami branch ordered to cause their associates or colleagues in Cayman to turn over some Cayman bank records, which of course in 1985 was problematic because it was thought in that time that the bank secrecy laws in Cayman were sort of absolute, and that no one should tamper with them at all. And how could the judge deal with this this vexing issue of extraterritorial reach in exercise of U.S. subpoena power? Arnie, just a paragraph on that.
Sure, Ed, and I'll add something about a more recent case using the 1782 statute, not handled by our firm, but locally here, one of the judges ordered the production not too long ago of records in Ecuador after the agency of the Ecuadorian bank was subpoenaed here. So it can happen now.
Has a bank made a good faith effort to comply? If they can show the court that they have done their best, fair enough, fair play to them. But again, we have many questions to ask about what that means. Options. Can records be obtained elsewhere, foreign branches, which may have longer retention periods? Where is the head office in the world, the global office? Do they have a consolidated set of servers there, amalgamating all records around their global system? Again, archival records, legacy data, historical data of the bank, residual data may be recoverable even if deleted, as I mentioned. Network topography maps may point to location of evidence. We talked about archives. It's another whole area of learning about how systems work in clouds, which means companies like Microsoft or Google now have massive servers in Utah or Colorado that's collecting massive data from all over the globe, and these servers are very valuable to access. One problem I think we have in the United States, though, is when you want to get email discovery of emails. I'm working on one Ukrainian case where we needed emails. We had a Google account, Arnie, where there was some nefarious traffic going on, and we needed access to the emails. So I thought of the silly idea, well, why don't we go to a U.S. federal judge in Utah where the cloud is located against Microsoft or Google and seek an order to have them open up their server and get us the emails. And what is the problem there?
You run into statutory authority that says no.
So why is it that emails are different from bank records? Why can I get bank records with a 1782 power, which are pretty sensitive private pieces of data, but not an email?
Yeah, you know, like you said, some folks are able to get good lobbying and good statutes.
So you're saying that Google and Microsoft did a good job for protecting the clouds, is that right? Access rights. Legally enforceable rights of access may be embodied in financial legislation, freedom of information legislation. There are many records that are reposed in government, and surprisingly, Freedom of Information Act requests are usually free of cost. You write a letter, you ask a government department for information, and surprisingly, you get back data. I worked on a case involving representations to the U.S. State Department by a foreign government. I did a Freedom of Information Act request, and I got all these private diplomatic notes that I had no way of getting discovery anywhere else, just from a Freedom of Information Act request.
Can take some time. I don't know how long that took for you.
Privacy protection, archival, and legal process law. Now, I think, Arnie, guidance from the courts.
I was going to close with one example of a case. It's actually difficult to find case law here in the U.S. dealing with banks that don't behave in the discovery process or with the production of records. In part, that happens because discovery matters in the federal court system are dealt with by magistrate judges who don't always publish their opinions. In this case, it was actually a report and recommendation being made by the magistrate judge to the district court judge in the Eastern District of Michigan. But some of Martin went over the prior slide quickly. It was his the moral of the story, and he had some lessons in the prior slide that I thought were good. And what they tell you basically is that you have to be persistent when it comes to getting records from banks. And so this case, if you'll go on to the next one very briefly, Gamby versus First National Bank of Omaha, shows you how a persistent plaintiff was able to get at some very interesting information. And this is a bank, not over bank records, but here they were looking for the policies and procedures employed in the handling of accounts. It was a case under the Fair Credit Reporting Act, and the court there noted that under the FCRA cases, you are typically looking at those documents. Those documents are going to be at the heart of the dispute, and the plaintiff was looking for them. First National Bank of Omaha resisted the discovery for years, represented that only fragments of certain manuals describing the credit policies and procedures in use at the relevant time remained in existence, that the manuals were not maintained in electronic form, and that those that did exist had been changed and they could not retrieve the ones that existed before. Ultimately, after years, the plaintiffs discovered that the bank's credit procedures had been audited by a third-party company, and they went after the discovery with the third party. And so this is Martin's point. Can you get around the bank, the problem with the bank, by going to some other third party that may have information about what you're looking for? And almost immediately, well, you had the third-party fight for a little while, but almost immediately after they agree to produce the procedures, the bank turns around and turns over the records that had been unavailable for years before that. Can I hit one more?
Sure.
They tell the judge, are we on the last one? Yeah, we were. They tell the judge that they are only able to produce these things after a, quote, screen by screen and folder by folder review, without an explanation as to why they could not have done that before. The judge concludes that the bank's attempted explanation was unworthy of credence, noted that the bank was a sophisticated financial institution, that it engaged routinely in complex financial transactions governed by many statutes, that it employed substantial staff, in-house counsel, information technology personnel, and that it was virtually inconceivable that the bank had failed for 2 years to understand the nature of its own business records and the obligation to undertake a meaningful effort to comply with the request. The court ultimately, or the judge, recommended that because the bank's credibility had been, quote, exhausted, the performance, it said, could only be explained by monumental incompetence, inexcusable neglect, or purposeful evasion. And the judge recommended that the bank's answer be stricken and the plaintiffs be awarded judgment by default. So this is an instance where a discovery mishap, if you will, by this bank led to some very serious consequences. And there are other opinions out there that are like this. This litigation was interesting. There were several plaintiffs, so the bank was more successful vis-a-vis other plaintiffs, but an interesting example of how the representations that the bank was making about the unavailability of this evidence came back to haunt it in a very real way.
Are there any questions? Well, thank you for listening. Oh, sorry, one question.
I was interested to know if criminal subpoenas are more powerful than civil subpoenas.
Well, the Bank of Nova Scotia case I mentioned in 1985 was a criminal grand jury subpoena directed against officials of Bank of Nova Scotia in Miami, ordering them to turn over records of Bank of Nova Scotia Cayman. And in that case, the court decided that it had power to do that and threatened the officials in Miami of jail, contempt, unless they caused their colleagues to cough up the records. So it did work. That was a criminal case. I'm not sure, though, I don't know enough about the criminal. I think it depends on the jurisdiction to be able to competently answer that question, because the power of criminal subpoena changes from place to place.
In this,
Following on from your comment about email, you attempted to go after somebody like Google. My understanding is that most financial institutions have very organized ways of saving emails so that they have a record of their communications with their client about, say, a mortgage loan, etc. And I just wondered if you had any comments about obtaining those records in parallel to the financial records.
It's a very good question. And I've included requests for emails, and sometimes we get them, and sometimes there's a big fight over whether we are entitled to them or not. Also, AML records are important in a lot of fraud cases, particularly if we're going to seek remedies of damages against a bank for perhaps dishonest assistance. And banks typically on those records say, well, our suspicious activity report filings, our early warning AML system, and our behavior to override that system of red flags in a fraud context, that's proprietary, it's not customer records, you're not entitled to it. So we usually have a big fight over the very central piece evidence in a dishonest assistance case. But so obviously banks are reluctant to share that data, but they get ordered to share it in that context.
And voicemail?
Voicemail is a very good question. It's oftentimes forgotten about. I would suspect that even though it gets deleted, that experts could interrogate it. If there was some, but you'd have to show a really compelling reason to put a bank through the process of gathering. I don't think you just randomly get old voicemail.
Let me rephrase my question, please. Any telephone conversation with a major financial institution is usually recorded.
Correct, and you're told in advance this is being recorded.
Therefore, where's the record of that kept? They have the ability to store them according to the subject, topic, or even the account number.
It's true, it's correct, and it's a good idea, and the next subpoena I issue to a bank will have that in there.
I agree that in this day and age, my voicemail generates an email with a voice file, and that's a very good idea. We were local counsel in a case where, and Martin was counsel on that case as well, where the lawyers in New York were able to obtain transcripts, I believe, of the calls
Correct.
at the bank, and there was a criminal angle there. To answer your first question about criminal subpoenas, Martin is correct. Obviously, in a place like Switzerland, for example, the criminal world can open up lots of avenues
Yes,
that the civil world can't.
we did a disservice in this presentation because we focus, as we usually do, on English-speaking Anglo-American jurisdictions. The civil law tradition, the great continental civilian legal tradition, Spanish, German, French law, they give birth to a whole different vista in fraud investigations where the victim can have standing in the criminal inquiry, work with the investigating magistrate, share evidence, have standing to get restitution or compensation, and be a party to the case. So that is radically different from our system. Also, civil litigation in Switzerland does not give rise to discovery powers. So we find ourselves in the criminal system when in our colleagues in Europe, in their legal systems, we're in the criminal system, and here we're in the private litigation system. Any other questions? Well, thank you so much for your attention this afternoon. I hope you enjoyed the presentation.